It is the Here We Go Rapid Review, and you are guaranteed to be swept away by the scintillating legal content of the Uniform Commercial Code's provisions regarding warranties. Here we go.
Let's move on to our next big area, very exciting, and talk about warranties. So here's some important general observations about warranties. Keep these in mind. They'll keep you from going off in the wrong direction when you're talking about warranties. This first one's important because a lot of people intuitively, this doesn't seem right. But warranty liability does not depend on fault. You can be super innocent and be liable under a warranty. It doesn't depend on fault at all. If your product, if you sell a car, and when it drives away, the wheels come off, that's a breach of warranty for sure. What if it was some ne'er-do-well spy who came in and took all the lug nuts off of the wheels? It doesn't matter. I know it's not your fault, but that's a breach of warranty. Warranty liability can happen also without any contract between the plaintiff and the defendant. How can you have contractual liability when a party's not a party to the contract? Yeah, see, warranty liability is not quite contractual liability. It's a little bit magical that way. Warranty liability has some features of tort liability, it has some features of contractual liability, and it has some dissimilarities with both. And at least as far as I'm concerned, I think it's best to think of breach of warranty as its own kind of action. Neither tort nor breach of contract. Breach of warranty is its own thing. If you just conceptualize it that way, it will help you avoid some problems. Here's some kinds of warranties. We'll run through these. Warranty of title, warranty against infringement, implied warranty of merchantability, implied warranty of fitness for a particular purpose, and express warranties. Let's talk first about warranty of title. This is the most important thing probably in the entire UCC Article 2. If I buy something, I want to own it afterwards. It'd be pretty surprising if I didn't. That's what the warranty of title is all about. So the warranty of title arises in every contract unless excluded, disclaimed, or modified. It warrants that title conveyed is good, transfer is rightful, and that it's free of any security interest or other lien, except what is actually known to the buyer and should have known doesn't count. You can see the UCC is pretty tough here on warranty of title because that's sort of the whole idea of a sale, that I end up owning it after I bought it. Now note that for an effective disclaimer, if you have an effective disclaimer of the implied warranties, we'll talk about what counts as an effective disclaimer of implied warranties later, but an effective disclaimer of implied warranties does not count as an effective disclaimer of the warranty of title. It's not considered an implied warranty that way. If you want to disclaim the warranty of title, if you want to sell something to someone that you don't necessarily own, then you need specific language or very, very particular circumstances that would put a buyer on warning, such as selling unclaimed property at a police auction. Then, I get it. I might not have good title. Next, the warranty against infringement. This arises on goods sold by merchant sellers. This is one that applies to merchants who are regularly dealing in goods of the kind, unless excluded, disclaimed, or modified. It warrants that the good can be possessed and used normally without a rightful claim of infringement by a third-party holder of some intellectual property rights. You sell me a printer, I should be able to use it without getting sued for patent infringement by someone out there. That's the warranty against infringement, at least if I buy a printer from the office store. If I buy a printer at a garage sale, that's not a merchant, so I'm not going to be able to come after them for the warranty against infringement. Now, in terms of disclaiming, this is the same as the warranty of title. An effective disclaimer of the implied warranties does not disclaim the warranty against infringement. You need specific language or very particular circumstances. Let's come to one of the big ones. This is probably the biggest one. This is like Boardwalk on the Monopoly Board of Warranties. The implied warranty of merchantability. It arises, thanks to its name, merchantability, you could probably guess this, where the seller is a merchant of goods of the kind, unless it's excluded, disclaimed, or modified, and it warrants that the goods are merchantable. I'm going to talk about what merchantable means in a second here. If you want to disclaim the implied warranty of merchantability, then you have two alternatives. You can either mention the word merchantability and be conspicuous, or you can use a phrase like as is or with all faults that everyone understands to mean that there's no implied warranty of merchantability. So either mention merchantability and be conspicuous, or use as is or with all faults or similar language. Okay, what does merchantable mean? When something is warranted to be merchantable, what does that mean? It means that it is fit for the ordinary purposes for such goods. So if I buy a car, I should be able to drive it. It warrants that it is adequately contained, packaged, labeled. If I order eggs, they should not come loose in a Ziploc bag. Merchantable means that they would pass without objection in the trade under the contract description, that they will run within quality and quantity standards of usage for trade in the contract description, that they will conform to the promises and affirmations of fact on the container or label, and much more. Note that the implied warranty of merchantability applies to used goods as well as new goods, but a merchantable used car is different than a merchantable new car. The implied warranty of merchantability is saying a little bit more about a new item rather than a used one. Let's talk about the implied warranty of merchantability in personal injury contexts. There is overlap between strict products liability in tort and breach of the implied warranty of merchantability under the UCC. You can use both of them to sue if you're injured by a product, but the doctrines are different and occasionally may reach divergent outcomes. So if you've got a personal injury situation from a product, you want to think about both the implied warranty of merchantability and strict liability in tort, and think about them independently. Don't try to interact them. Just work through one and work through the other and see if you can make a claim work under either one. For strict products liability in tort, the question is whether or not the product has a defect, and that may involve inquiring about consumer expectations and cost versus benefits of alternative designs. For breach of the implied warranty of merchantability, the question is whether the good was merchantable, which generally comes down to whether or not it was fit for the ordinary purpose for which it was used. So if you drive off in a car and the wheels come off of the car, that's an unmerchantable car. And they have different requirements, so you want to think of those differently. Let's next talk about the implied warranty of fitness for a particular purpose. The implied warranty of fitness for a particular purpose arises where the buyer has a particular purpose for the goods, and the seller has reason to know this. And the buyer is relying on the seller to help select suitable goods, and the seller has a reason to know about this reliance. Okay, you go to the store to buy a certain pair of shoes. You say, yeah, I'm planning to run a marathon, and it's the special running shoe store. They say, oh yeah, I've got the shoes for you. They're these over here. But after 10 miles, they disintegrate under you. Then you'd have a great case for implied warranty of fitness for a particular purpose. So the implied warranty of fitness for a particular purpose, what does it warrant? That the goods are fit for that purpose. I mean, that was pretty easy, what you might expect. And there's two alternatives for a disclaimer: a conspicuous written disclaimer, or use of as is, with all faults, or similar language. Next is express warranties. An express warranty doesn't arise by default under the UCC. It's not implied by the transaction. It comes from what the seller is expressing. So it arises when the seller makes an affirmation of fact, promise, or description relating to the goods that become part of the basis for the bargain. Words like warranty and guarantee are not necessary. There's express warranties everywhere. You pick up a can of soda and it says that it contains 0 calories. If it contains a bunch of calories, that's a breach of an express warranty. There's express warranties all around. It doesn't have to have some kind of gold seal on it and say warranty. It's any time there's an affirmation of fact, promise, or description relating to the goods. So an express warranty warrants that the goods will conform to that affirmation of fact, promise, or description. Theoretically, an express warranty cannot be disclaimed. How would that work? So I warrant that this soda has 0 calories, and I disclaim that. Might have any number of calories. That's ridiculous. So you really can't make an express warranty and disclaim it at the same time. It makes sense to disclaim warranties that arise by implication. You're saying, don't take that implication. I know you think you think that this is going to be merchantable, but I want to dispel that implication. But to make an express warranty and disclaim it at the same time makes no sense. But, because this is a little tricky, the effect of a disclaimer can often be achieved in practice through the use of the parole evidence rule. You go to the car lot. They say, oh, this car runs great. New tires, new shocks. It'll run for 50,000 miles before you need any work on it. You're like, great. And then you sign the dotted line, take the car, pay your money, and the car breaks down as it's driving off the lot. So an express warranty was made. You can't really disclaim it, but if you have a fully integrated contract that says all the terms are in here, then you've achieved, in effect, the disclaiming of an express warranty. What are you going to do in a situation like that? You're going to depend on consumer fraud statutes or a common law fraud action. There's all kinds of federal regulations about selling cars. There's other things that can protect you in that situation. But when the express warranty and the parole evidence rule meet with a fully integrated contract, you can get some pretty unexpected and shocking results for a buyer. Next, warranties, privity and remoteness issues. What about when I want to sue someone for breach of warranty, but I don't have a contract with them? So I want to sue an automobile manufacturer for breach of warranty, but I didn't actually buy the car from the automobile manufacturer. I bought it from a dealership. So how does that work? If you bought an item from a retailer, who bought it from a wholesaler, who bought it from the manufacturer, who can you sue the manufacturer, the wholesaler, for breach of warranty? How about if a guest is in your home and they are injured by a product that you bought? Can your guest sue the seller for a breach of the implied warranty of merchantability? And the answer is that it's complicated. And so we're not going to stop to go through it all. But you should understand that you can't assume that you need privity. There are some circumstances under which you can sue, even if you weren't the purchaser of the product, from the warrantor, and in some circumstances where you need privity. It's complicated, but don't assume that you need privity and don't assume that you can get by without it. For a concise review, I have a handout. There's a link to it. I'll let you look at that if you want to, and you can work through it. It's complicated, but make no assumptions. And this is part of why I say it's just best to think of breach of warranty as its own thing. It's not breach of contract. It's not tort. It's got some features of both and some dissimilarities. So just think of breach of warranty as its own beast. Now, we need to talk about notice. To have a claim for breach of warranty, any of the warranties, under the UCC, you must give notice within a reasonable time after you should have discovered the warranty breach. If you don't, you will be barred from any remedy. This is a huge potential pitfall for warranty claimants, and this is an easy get-out-of-jail-free card for defendants. So here's a practical tip. If you have a potential warranty breach, send out notices to everyone you can find in the chain of distribution and send them out as soon as possible. They don't have to be real complicated. Just get something out. Start notifying people. Yeah, wheels came off my car. Notify everyone you can and do it quickly to preserve your ability to bring a warranty claim. In the sales course, we read a lot of heart-tugging cases about terrible injuries and things where plaintiff was left with no claim because they did not get notice in within a reasonable time. A final note on warranties beyond the UCC. There's more to warranties than just what is in the UCC. In particular, the Federal Magnuson-Moss Warranty Act, which is at 2301 at sec of Title 15 of the United States Code, has a huge effect on consumer warranties. The Magnuson-Moss Act is the explanation for much of what you see in the little slips of paper that come with your products, such as 90-day limited warranty. Why does everything say that? It's because of the Magnuson-Moss Warranty Act. I'm not going to get into that, but if you want a full picture of warranties, you should look at the Magnuson-Moss Warranty Act. There are also various state consumer protection statutes that can be an important source of warranty law as well. A lot of things that you can weasel out of under the UCC as a seller, you can't get away with that under Magnuson-Moss, under state consumer protection statutes. So for a full picture, explore that.